Also, I would like to hear Meta tell the children being abused that there is no rush to this issue.
So, pages 2 and 3, please. Case 886110, State of Nevada versus Meta Platforms, Inc. Counsels for plaintiff. Can you please do your appearances?
Good morning, Your Honor. Aaron Ford, Nevada Attorney General, on behalf of the state, with my colleague Mark Kruger with our Bureau of Consumer Protection.
Good morning, Your Honor. Michael Gayan, Randall Jones, and Don Springmeyer from Camp Jones in court today. We also have Mr. David Slade, who's been admitted pro hoc vice. Also in the courtroom, we have our co-counsel Phil Carlson, whose pro hoc application is pending, and Brian McMath, also co-counsel. His pro hoc is forthcoming. He's waiting on a certificate from one of his state bars. Then we also have Ms. Raquel Fulgham from the Attorney General's office, between Mr. Carlson and Mr. McMath. Also on the back row, we have Investigator Anthony Gonzalez from the state. We also have Mr. Christopher D. Fonseca. And way in the back corner, we have Dr. Jennifer Goldbeck, and those are our 3 potential witnesses for today.
I'll just need spellings of those last 3 at some point.
Sure, no problem. And I believe we have several people on the Zoom. Looks like Miss Katrina Stark from Kemp Jones, and then we have Miss Whitney DeGesti from the Attorney General's office, and also Anthony Walsh from the Attorney General's office, Michaela Holweiler from our co-counsel. And by the way, all of the folks on Zoom will just be observing, no one will be participating from Zoom. Also, our co-counsel Brian Moore observing, and I believe that is everyone, Your Honor.
2 other individuals just walked in a few minutes late. Did you need to introduce them?
I don't know these.
Sorry, Your Honor, we're from the ACLU. We were asked to be here by the state.
I need a name, please.
Chris Peterson, bar number 13932.
And there was a second individual?
Tara Sigula, bar number 13646, Executive Director for ACLU Nevada. Can you spell it?
We're going to need you
Yeah,
closer
and
to a
your mic.
microphone, please, so we can actually hear you. And are you,
And spell it.
Yes, I won't be appearing on the record.
are you just observing the?
I'm just observing.
No, I do
so-
need it because he said it.
Okay, all right, got it. No problem. First name spelled A-T-H-A-R, last name H-A-S-E-E-D-U-L-L-A-H, bar number 13646. Thanks.
Okay. So taking care of everyone on behalf of plaintiff.
Yes, Your Honor, thank you.
Thank you. Other side of the aisle, counsel for defense. Go ahead, please.
Good morning, Your Honor. Tammy Peterson, bar number 5218 for Meta Platforms, Inc. With me at counsel table is Tim Hester, who's admitted pro hoc vice in this case. Behind me is David Sneed, who's also admitted pro hoc vice in this case. Present here in the courtroom was Mr. Mike Ambrosio. There we go. Present as well. And I'm going to turn this over to Mr. Hester to introduce all of the other individuals who are here in the courtroom, Your Honor.
Okay. Go ahead, please, whoever you wish.
Good morning, Your Honor. Timothy Hester of Covington and Burling. Let me introduce some of my colleagues who are here. Emily Ham from Covington and Burling, one of my partners. We have Gavin Jackson from Covington and Burling. We have Patrick Nutter from Covington and Burling. We have Ansel Carpenter from Covington and Burling, also in attendance. Let me ask also Mr. Dan Waite. Dan, would you like to introduce yourself, please?
Good morning, Your Honor. Let me come up by a microphone. Dan Waite. Dan Waite and Dan Polsenberg, Abraham Smith, and Stephen Steele for Lewis Roca.
Okay, thank you. So everyone taking care of the defendant's side.
Yes, Your Honor.
Okay, so welcome. As you notice, this is the day that was set aside for preliminary injunction. You're also familiar that not only yourselves counsel for the actual parties and others, there's a plethora of pleadings, and there's, as to use a word that I used on February 26th, there is some conundrums that we need to address up front. But I think, before we get to some of the court's ones, is there a couple of things that are quick and easy that the parties have agreed to that the court should be aware of by chance? Is there maybe a couple of minor issues that the court parties have agreed to? If you have, why don't you let the court know, we can address those first off, and then we'll address other issues. Go ahead, please.
Yes, Your Honor, I think Mr. Springmeyer and Mr. Sneed are going to address some of, or at least identify the list, and then we can get input from the court on how to proceed.
Well, hold on a second. We're going to do these one by one. Is there anything quick and easy? For example, I got motions to associate from Lewis and Roca. Those are taken care of because those are internal attorneys. Is there any other attorney issues, any pro hacs by chance that maybe the parties wanted to see if there was agreement on?
Yes, the pro hoc for Mr. Phil Carlson, which we have remedied the issues that Your Honor identified. The opposition has filed a non-op, the defendant has filed a non-op. So we'd ask to advance that hearing to
Mr.
now.
Springmeyer,
And
Mr.
Mr.
Springmeyer, can you get a
Brantley.
little closer to the microphone for me?
My court reporter is going to remind you, just if you don't mind, we just need to have you pretty much within arm's length of, and that's a short arm's length of a microphone. Anybody who's speaking, just so we can never hear you all. No worries, feel free to close it if it's easier for anybody and they want a pocket microphone, we do have those available. So if anyone wants them, you can also let us know that as well. Go ahead, please.
Understand, thank you. I believe that's probably the only quick thing.
Okay, counsel for defense, is that correct?
Good morning, Your Honor. Tammy Peterson for the defense. And we don't object to advancing the hearing on that pro hoc, and we did file a notice of non-opposition to the admission of that individual.
Okay, so what the court had already had an opportunity to review that pro hoc VJ application. It meets the standards. The court is going to A, advance it pursuant to EDCR 2.23 to today, grant it as unopposed pursuant to EDCR 2.20, and the specific non-opposition of defendant. Matter platforms. It is so ordered, so we just need an order. Please submit it to the DC 31 inbox pursuant to the administrative order. Okay, but nobody, just for a point of clarification, this court's understanding is that it was unopposed that is anyone requiring that the order be signed and there be a notice of entry of order before Mr. Carlson partakes in case he's planning on partaking in today?
No, Your Honor. Thank you for asking. No.
Thank you, Your Honor.
And you don't wish that to occur either, right? Meaning, you want him to be able to speak today, correct?
Likely, Your Honor.
Okay, if he wishes to, okay. So since there's no objection, nobody's doing the requirement with regards to the actual formal order, since that's waived, the court's going to grant it. And if it is appropriate and you all choose, then you would be able to participate in today's hearing.
Thank you.
Okay, thank you.
Then,
Let's go to it. The next thing on your list is, and then we're just going to take these one by one, I think is going to make the most sense, right? So-
yes, Your Honor. May I approach and hand you a list?
It's okay with me, defense counsel's okay with it?
Yes, Your Honor.
So you can just hand it to the marshal, he'll give it to me, thanks so much.
And this is merely a list of topics, except for the top one, which I guess is simple too. That's the agreement of the parties to split the time 50-50.
Okay, well. Okay, so I'm going to jump ahead because we're going to deal with some of the things that were procedural first. It makes more sense rather than some of your actual motion practices and objections. So it looks like number 6, how to handle the presentation of references of sealed redacted material. And that
Yes.
was a question that the court was going to need to ask, and I'm sure all of you are appreciative. We do have 2 media requests the court signed, but each of those media outlets saw in the request that the court signed the order. Actually, you saw I put other, and you saw the specific language that the court needed to put because there is already a confidentiality stipulation in place in this case, and there's certain requests already that either have been granted or are pending with regards to sealed and redacted information. So this court needs to balance all of those, right? Not only in accordance, and this is an interesting, different procedural conundrum. As you all probably are familiar, there's a recent Supreme Court case, but rehearing was just granted on 3/18. And so, but the court, regardless, would be doing the appropriate analysis it needs to do if there is a request at any point in this proceeding to request that there either be no longer people on Zoom, or if there's a request not to have certain of the aspects of today's hearing to be recorded. So I guess I'll ask you the short question. Is there going to be a request to not have a recording in any part for today because of some of those court's prior orders, or something that the parties are going to present to the court? If so, let's address that part first, and then we'll deal with the partly redacted aspects next. Go ahead, counsel.
Yes, yes, Your Honor. David Sneed from Covington and Berlin on behalf of META.
Sure.
And I'd like to address this point about sealing. It is our understanding from the state's disclosure to us that they intend to use a wide variety of documents that were produced by META. The parties previously entered into an agreement where the state agreed these materials would remain sealed. Given that agreement, the state had moved to seal the documents they appended to the reply brief, for example, and other documents that they had sought to use in these proceedings. And the court has granted, like as the court noted, the motion to seal for those materials on the basis of the parties' agreement that the expectation is that these materials will remain sealed.
Just for a point of clarification, it wasn't only on you all's agreement. This court did an independent analysis as it needs to do under Supreme Court Rule 3 and other applicable case law before it makes such a determination. So it was a little broader. Go ahead, please.
Yes, Your Honor.
Nevada law is pretty specific on that, so I wanted to make sure you all understood that I did the full analysis. Go ahead, please.
Thank you, Your Honor. As we understood it, the state stood by their obligations under the agreement that they entered, and the court has separately done its own analysis, as the court explained, and reached the conclusion that they should remain sealed. It's our position that the materials that the state seeks to introduce for the purpose of this hearing falls well within that same universe and should remain sealed. And thus our proposal would be that any time in this hearing that would address the documents that are at issue based on that agreement and based on the court's prior order and analysis should also be sealed, because it remains within the same world of protected information. And so the testimony that would go to those documents should be just as sealed as the documents themselves and should be protected. And so the portions where the state seeks to introduce those documents and use those documents with witnesses or speaks to the contents of those documents should be a sealed courtroom when that happens. So that's META's position with regard to the sealing of the courtroom. It is not our position that the entirety of the proceedings should be sealed. There are several things that have been filed in the docket publicly that don't require that protection in terms of the arguments that the parties have made. But when it comes to META's internal documents, our position is that should remain sealed according to the agreement in the court's order, and that those portions of the hearing that reference those should remain sealed.
And from your position, can that be clearly delineated? Meaning, can you say, well, this testimony, we're about to ask this question, or this document's about to be introduced, and so therefore it should be sealed? Or how is your proposal in order to handle that, balancing everything that this court needs to balance with the public's right to know, that this is a public proceeding, right? But then there's also some prior court orders. Do you have a proposal?
My proposal is that any time that the state intends to introduce a document that is permanently sealed or has been agreed upon previously to remain sealed, then the hearing should hold, and we should move into that sealed session, those portions be sealed, as well as any time the state intends to ask a question revealing the contents of the documents or materials, or when the state makes an argument that would reveal the contents of those materials.
Okay. Before I get to the state, because I'm going to ask you some of these same questions, let's walk through a couple of different things, okay? Are the documents, and I appreciate sometimes people want things electronically. In fact, you all requested that you have an IT person here, right? So if they're put up on the screen, they're put up on the screen, right? There's not a way to seal things that are put up on a screen, realistically, because everyone can see it as soon as they're put up on the screen. But I understand that at least one side has some hard copy documents, maybe both sides. I know some received late last night, and I believe some may have come in this morning. So are all the documents, focusing first on documents, are all the documents in a hard copy format so it could be presented to a witness or referred to by counsel without it going up on, I use the term screen, you understand, I mean the TV monitors in electronic form, right?
The documents that both sides have exchanged that are part of the exhibit list that either party has exchanged and prepared to use for today's hearing include hard copy documents which have been printed. We have binders for either side's exhibits, and so all of the exhibits would be able to be used in hard copy with witnesses. I think my only my only concern is to the extent that even if it's not shown on the screen, the questions are revealing the contents of the documents, we still maintain that should be sealed, even if the document is not going to be shown on the screen.
Okay, that was gonna be my next part. I'm breaking it down piece by piece. Okay, so testimony, with regards to testimony, are any potential testimony, are the witnesses here or any of them audio-visually potentially they're going to come up because that presents a different issue depending on the format that they were potentially going to appear?
My understanding is that each of the witnesses that were anticipated to testify at the hearing are present. At least that's true for Meta, and I understood that to be true for the state as well.
Okay, so thank you so very much. So is that an agreed upon position or should I be asking the state their position? I'm going to ask them anyway, but
I do not believe that is an agreed upon position.
let's hear the state of Nevada's position. Go ahead, please.
Good morning, Your Honor. Michael Gayan for the state. I guess the only distinction that the state would like to draw from the prior motions to seal is now we're here in open court in a public hearing, as opposed to the state complying with its obligations under a confidentiality order signed a couple of years ago. I know the court is aware of the recent Falcone decision, and there's a strong policy in Nevada in
And
favor
you
of
understand
public
that
hearings.
petition for rehearing was the 318 I was
And
referring
there's
to.
yeah, I understand there's been an extension granted, so I understand the remitter has not issued.
No, there's a brief that was actually.
Oh, the brief was- okay.
I understand that one was an extension, but at least, and I have not checked, I've been a little busy with my own docket, but I had understood at least one brief was filed. And I could be incorrect, that was just general information.
It's likely, I understood that at least a petition for rehearing was on its way. So I understand remitter has not issued on the Falcone decision. However, I think Falcone doesn't necessarily change the law. It just clarified it. There is a strong presumption that hearings are public. And so that's the only distinction. We have not moved to seal anything in open court in the hearing. We have complied with the state's obligations to file exhibits under seal, and we've done that. And the court has done its analysis. We believe sealing of the filings was appropriate, but we leave it to the court's discretion on whether sealing of a public hearing is appropriate under the circumstances with, obviously media requests here. And the practical concern from the state side is also the time management issues of shuffling in and out of court and the limited time we have today. So that's another consideration. I'm not saying that should trump Meta's potential right to have things sealed. However, that is a concern. Thank you.
Do you have any case law or anything that sets forth that once a court's already signed a confidentiality order, right, and has already sealed certain documents, just merely the fact that they're going to hearing, in fact, in cases involving here previously, that somehow that hearing would take away the court's prior order?
Your Honor, we do not have any cases on that. But at the same time, Meta hasn't presented in their objection they filed last night. I didn't see any cases talking about sealing of public hearings, neither or delineating that specific issue. At least it was served on us late last night. So they did raise some issues with our exhibits and raise some sealing questions in there.
Okay, here's what the court's going to do. The court's going to really take it on a request-by-request basis. I think that is the proper balance between the various aspects, because we have to take a look at it as something that is just by agreement of the parties versus a court order. We need to see the nature of it. We also see if it's the nature of, quote, a proceeding versus a document, or a combination thereof. The court takes no position on cases that are pending before the Nevada Supreme Court, subject to any rehearing, but I just think that is the appropriate balance consistent with prior case law and all the indications that this court has read. I think that's going to make it the easiest. I'm going to take long, extensive, which is going to basically see where somebody wants a certain part sealed, see if there's an agreement by the state, or if they're going to want some argument, and go where that needs to go. I'm appreciative of the time issue, but at the same time, we want to make sure that everything is done in accordance with applicable case law and rules is the best, for everybody's cases. So does that take care of that issue? And that equally applies. So what I am going to ask, though, if there is a document that you already know is going to be one of those documents that there is going to be the request. Really, on that one is a time efficiency. Is there any reason we can't use paper documents for those that you know are specifically confidential and not use the electronic version? Because once you put it up and then I get an objection, you can appreciate that that ruling would be a little bit challenging once it's already up. And I don't want to use the cliches of barn doors and things like that. Go ahead. Counsel for the state, would that meet your needs or not?
Yeah, Michael Gayan for the state, Your Honor, thank you. And Mr. Jones and I were just discussing, based on Mr. Sneed's objections, I would even give him a heads up before asking a question that would be reading from a confidential document. So we're happy to make this process easier on everybody.
Okay. Does that meet the needs of Met Platforms?
Yes, Your Honor.
Okay, thank you so very much. So that took care of that one. Okay. So I am next going to go to, because this impacts what pleadings potentially the court can take into account. I'm going to go to the what have been filed. Either one was contended that it was an amicus pleading, and then a couple other aren't even set for hearing until April 16th, right? So they're not even set for hearing today for leave to file an amicus pleading. Okay, so the court's going to have to address that. The court has, and I will tell you, the court did not even receive courtesy copies on some of these potential motions for leave to file amicus briefs and the underlying briefs, and so you can appreciate that, particularly the timing of when these were filed, they were outside the court rules, and so the court has that concern it needs to address as well, balancing it with, obviously, that at least in one, it says that there was an agreement with one side to do it, although there was an objection to how it was done with the appellate rules. So I kind of have an interesting conundrum with a couple of different aspects. So here's what I'm going to ask to the councils in general, okay? It appears that there are some requests to file amicus briefs, which is the proper course potentially here in Nevada, because amicus briefs are not a matter of right in a district court proceedings. The rules of appellate procedure do not apply in a district court proceeding. Yes, I have read the Hare case and I'm familiar with the school voucher case, but that was a permissive and a right to intervention case, and some dicta on the last page on the analysis of permissive intervention as to the fact that in that case the court did say that there potentially could be, the court potentially invited some supplemental / amicus briefs. And so no one has presented this court anything on point as to a right to file amicus briefs. While at the same time, I appreciate this is a very important issue, as a matter of public policy from everyone, and both sides have had, I'll call them documents at this juncture, documents that were filed, some of which were provided to the court, some of which were not provided to the court, some of which aren't even set for hearing, as I mentioned a moment ago, until April. So I'm going to throw out a question to see maybe if the parties agree. Would the parties potentially want to agree that the court consider all of the documents filed by third parties, regardless of which side they were on, regardless of what the timing of when they were filed, and so that the court considers all of those documents? And like I said, right now I'm calling them documents. Some are titled as motions for leave to file amicus briefs and an exhibit attached thereto, and one was filed without court permission. And so that is really just a question out there that maybe that might meet the needs of the parties, since on both sides there have been these third-party documents. Now that doesn't address that in at least one of the documents, people said that there was a pro hoc vice, which, yes, if you look at the caption, it was pro hoc vices, which I'm not sure on how that comes when there is no pro hoc vice applications pending. Others put their name on it even though they're out-of-state counsel and they're not even having a pro hoc vice pending, and so people put names on pleadings, which under Nevada you all know can't be done without being admitted. So you can appreciate there are a lot of challenges in those areas, but at the same time, like I said, the court's balancing. You know, this is definitely a case of public interest, and so sometimes the view, since each side seems to be arguing, despite the breaking speed, I think it's called, that this is a proceeding of public interest, and both sides seem to have some third parties that wish to have an opportunity to be heard. So my long version of a really simple question is, do the parties wish to stipulate that the court can consider all of them? Or if that's really a simple yes or no. If the answer is no, then I will go to the next step of evaluating each of those briefs and give anybody who wishes to be heard to make a determination, as well as the parties. If the parties even say that those third parties can even present an argument, we go to the next step. Counsel says, and if you all need a few moments to discuss with your sides, that's perfectly fine too, because I am appreciative that sometimes people need a collaborative viewpoint versus an individualized viewpoint. So my preface question is, do you all need a few moments to talk base among yourselves? We should go off the record, or can you answer the yes or no now?
Your Honor, Timothy Hester on behalf of Meta. From our perspective, we are agreed that the court may consider all of what it has referred to as the documents. We agree that all of them can be considered by the court in relation to this matter.
Your Honor, Don Springmeyer for the state, we agree also.
Well, okay. So, there we go. So let's be clear on that listing of said documents. Because remember, since the court didn't get any courtesy copy, I want to make sure there's also something not out there that the court doesn't know about. The court is aware from the ACLU that I received both a brief and a response brief. Okay, so I think that takes care of that one. And just quick, counsel, would you mind coming to the podium? Because I'm asking a question. Is there any need that really you all are trying to get a pro hoc vice counsel into this case?
We do that occasionally. Oh, sorry, Chris Peterson from the ACLU. We often do that when we do file amici briefs before the Nevada Supreme Court. If
Oh,
national
in district court.
So, and I realize this is very unusual because again, we typically save our amici for the appellate courts. We're, I think like a lot of the parties here, trying to sort out along the way what the appropriate procedure would be. We have put an application for Ms. Granick at this point, and we're just simply trying to get that taken care of. If the court would prefer not to have her on the pleading, we can do that
Well,
as
there's
well.
rules on who can be on
Yes.
pleadings, which is
Right.
not a district court rule. As you know, that's a Supreme Court rule, and people have to be admitted in order to look like they are an attorney in a case.
Yes,
So,
and Your Honor, and just to be clear where that practice is coming from, what we did there, we've done that on the other amici before the Nevada Supreme Court. They've accepted it, but that's not what the court wants. We'll
it's not a matter of this court. The Nevada Supreme Court makes the rules. It's the
Yes.
Nevada Supreme Court rule. I'm a district court judge. I need to follow the Nevada Supreme Court rules. If they wish to waive something of their own rule, that's their decision. I'm a district court judge. I follow the rules.
Your Honor, if that's the case, would you prefer to file an amended with that neighborhood?
Let's address that. I don't want to take everyone's substantive time for today. Are you going to request to have any time to speak today? Because that's going to be a different question I have to ask counsels.
No, Your Honor.
Okay, so yours is brief only. Okay.
Yes.
Also received a document from the Chamber of Progress. Is there anybody here on behalf of that group? Okay. Nobody remotely? It's, okay, so then I'm just going to take based on, sorry, go ahead, please. I need a name.
This is Mark Zwillinger on behalf of the Chamber of Progress remotely. I did not anticipate being able to speak today, so I was not prepared for my attire. I apologize, but we are here and we have filed through local counsel, and we do not need to be admitted pro hoc vice either. Our local counsel is on the brief, and we are hoping that will be submitted.
Okay, so by agreement of the parties, that brief gets considered. Also, okay, also received one from the Child USA and National Center on Sexual Exploitation, and that was on behalf of the state of Nevada. Is there anybody from that group here? No.
Yes, Your Honor, remotely, this is Daniel Bravo, bar number 13078 of Bravo Schrager, appearing via Zoom. I believe our office sent courtesy copies yesterday. If they did not arrive, I apologize. But we also submit on the papers.
Okay. Those are the three that the court is aware of. And when I mentioned the Chamber of Progress, it had a whole bunch of subgroups listed there on its pleading, but okay. Is anybody aware of some other third-party document that the court hasn't noted that I should be taking into consideration? Because those are the three I'm aware of, and I've reviewed all of those. Go ahead, please.
Timothy Hester, Your Honor, we are not aware from Meta's perspective of any other documents.
Counsel for the state?
Your Honor, Michael Gayan for the state. We're also not aware of any others.
Okay, so that took care of that issue. Those all get considered. Okay. So, now these are more substantive, what the court should and shall consider if we pretty documents. It seems to make the most sense that I now address the, well, I've got Counsel for Meta, do I address the personal jurisdiction next, or do I address the objections to exhibits / supplemental declarations next? So I'm fine with either of those. I see one of those two seem to be next on the list. And I will, before you speak, counsel, I'm not sure if you are familiar, but at least some people at your table are familiar with. Remember, this court also has another case, 877-867, by Meta versus Meta Platforms, and the court's familiar with who has, here in Nevada, has not contested anything, right? So go ahead, please.
Yes, but Your Honor, I'm prepared to address the question of personal jurisdiction if the court would prefer to hear that next.
State Nevada, does that seem to make the most sense that I address that? Because that's kind of large before I get to each of your pleading aspects. It's up to you. If you say something different, let me know.
Michael Gayan for the state. Yes, that makes sense, Your Honor.
Go ahead, counsel, since it's your, now this, counsel, let's get a quick agreement on this. I was going to give each side one way to do, because this one's a little bit out of order, right? Because it came up in your opposition, so normally the state would have the opportunity in a general sense, right? All the arguments that are raised in their motion, you would raise what you wanted to raise from your opposition, they get last word. However, since this is personal jurisdiction and makes more sense for you to go first, are you all okay if each side just has one round of argument and then the court makes a determination? Or are you requesting something different?
Your Honor, I would request a brief period of reply, but if the court would prefer that I just argue once, I'm entirely fine with that.
Let me see what the state's position is, because it was their initial motion we're here for today. Go ahead, counsel of the state.
Your Honor, Michael Gayan for the state. For the reasons you mentioned, the state would like the last word on this issue. We're happy to separate it out from the briefing because Meta feels it's a threshold issue, and so we're happy to accommodate them, but we don't want to be prejudiced and lose our last word position.
And that's what the court's going to need to do, since it was issue raised in opposition, since I have a procedural question they do. Okay, counsel for Meta, remember, we've got lots of you, so each time anybody speaks, please make sure to remember to state your name and the party you represent.
Thank you, Your Honor. Timothy Hester representing Meta. And maybe just to address the court's point right out of the box.
It wasn't a point, it was just, you have to realize, I have a lot of counsel from all over the country that come in a lot of different cases, and not every time does everyone know that they have other cases that happen to be coincidentally in front of the same judge. So I was giving that heads up in case you weren't aware, although you probably were.
I was aware of that case, Your Honor, and I just wanted to be clear that that case involves the use of a trademark in the state, and so we see it as a fundamentally different personal jurisdiction issue from the question before the court. The critical overarching point here is that the state is seeking a preliminary injunction from a court that lacks personal jurisdiction. And we see this as a fundamental issue of due process. When the court lacks personal jurisdiction, it also lacks the authority to proceed, to have witnesses present evidence, because personal jurisdiction has not been established. And so that our record is clear, Meta does object to any presentation of evidence today until the question of personal jurisdiction is resolved. And I expect the court may resolve it, but I wanted to be clear on that point. The state bears the burden of establishing personal jurisdiction under Nevada law. It is required to present evidence on personal jurisdiction once the defendant contests it. The state cannot rely on allegations. And this is established by decisions out of the Nevada Supreme Court. In the Abbott Interfast case, the Nevada Supreme Court said the plaintiff has the burden of introducing competent evidence to establish a prima facie showing that personal jurisdiction exists. And in the Trump case out of the Nevada Supreme Court, the court said the plaintiff must introduce some evidence and may not simply rely on the allegations of the complaint to establish personal jurisdiction. We have a failure of proof on that point. The state has not presented any evidence to establish personal jurisdiction. But beyond that failure of proof, the state's arguments don't establish personal jurisdiction. First, the state does not allege general jurisdiction. That's conceded in its reply brief, page 2, footnote 1. There are two elements for specific personal jurisdiction, as I'm sure the court is aware. First, there has to be a purposeful availment by the defendant of the forum. And second, the claims must arise from the defendant's contacts with the forum. And the state has failed to establish either of these prongs, and it has to establish them both with evidence to support personal jurisdiction. On the first prong, purposeful availment, that requires some specific targeting of Nevada. It is not enough under the case law to operate a social media service that's accessible nationally. And that's established by the Briskin case that we cite in our brief, where the court, Ninth Circuit, said what is needed is some prioritization of the forum state, some differentiation of the forum state from other locations, or some focused dedication to the state that is something substantial beyond the baseline connection that the defendant's internet presence already creates with every jurisdiction through its universally accessible platform. That's one key point. A second key point is that purposeful availment cannot be established by third-party conduct, such as advertisers or users of Meta's services. And the Supreme Court of the United States said that very clearly. In Walden v. Fiore, we've consistently rejected attempts to satisfy the defendant-focused minimum context inquiry by demonstrating context between the plaintiff or third parties in the forum state. And the Nevada Supreme Court in the Tricarici decision said the same thing. Specific personal jurisdiction must focus on conduct the defendant purposefully directs at the state. And for this fundamental reasons, decisions by advertisers to target Nevada residents or decisions by Nevada residents to use Meta's services cannot establish purposeful availment. Now that makes complete sense as a matter of public policy. Decisions by third parties to use the services of a nationwide or international service don't reflect that kind of purposeful availment, some specific targeting of the state. Now the state relies on the Keaton v. Hustler decision out of the US Supreme Court. That involved physical sale of goods into the forum. And in the Briskin case that I mentioned before, the Ninth Circuit made very clear that personal jurisdiction cases involving claims against interactive websites are the right foundation for evaluating purposeful availment and not precedent involving the distribution of physical products. There's another decision that's quite important on this, Johnson v. Huffington Post out of the Fifth Circuit from 2021, where the court said, willfully applying Keaton to internet publications would vitiate the requirement that a defendant purposely avail himself of the forum, because it would be true all over the country. These internet service providers would be subject to jurisdiction in every state, and the case law rejects that outcome. So that's one prong, failure of purposeful availment. The state has not presented any evidence to support that prong. But there's a second prong. The claims must, quote, arise from Meta's activities in Nevada. And the Tricarici decision out of the Nevada Supreme Court, again, sets this out very clearly. The state cannot establish this prong. Meta's alleged connections, even if we accept them as true, relate to alleged advertising by third parties and by the terms of use that Meta has with Nevada users. But those contacts have nothing to do with the state's claims, which are based on alleged features that are alleged to create addictive or compulsive use of Meta's services, or alleged misrepresentations about the safety of Meta's services. That those claims are not arising out of the alleged contacts that Meta has with the state. The state's argument is that Meta is incentivized to create this supposedly addictive use of its services to sell more advertising. But that's the wrong legal standard. Motivation for Meta's connections is not the issue, and it's not the correct legal test. The claims have to arise from Meta's connections with Nevada, and the state's claims do not, and it's not made that showing with any competent evidence. I would emphasize again here, the state is really resting on its allegations of the complaint, which the Trump decision out of the Nevada Supreme Court says you cannot do to establish personal jurisdiction. So I will close on this point, Your Honor, by highlighting the Bristol-Myers case out of the US Supreme Court. When there's not a connection, the court said, between the defendant's in-state activities and the claims, specific jurisdiction is lacking regardless of the defendant's unconnected activities in the state. So just to close here, this is a due process bar to proceeding any further. If the court lacks personal jurisdiction, it lacks the authority to proceed to hear evidence today. Thank you, Your Honor.
Appreciate it. Thank you. Okay. Counsel for the state.
Thank you, Your Honor. Michael Gayan on behalf of the state. Your Honor, this analysis is actually pretty straightforward. There's 3 elements, and my colleague went through them, but the question is whether Meta has purposely availed itself of the privilege of acting in Nevada or causing important consequences in Nevada. That's the first prong or analysis or element the court has to consider. And the answer to that question, both of them, that there's an or, it's disjunctive. It's a resounding yes. And our papers are replete on this with authority. And Meta's arguing that we cannot just rely on our allegations of our complaint. Well, our complaint on all of the personal jurisdiction allegations also cites evidence, including, on some of them, Meta's own websites, where they make statements. So to say that our complaint is like the Trump case, where it's bald allegations, is false. We have cited evidence. It's unrebutted, uncontested by Meta, and it's their own admissions, in some instances, of their reach in Nevada and their impact in Nevada. We also have evidence here, and we heard no comment from Meta about it, that Meta Platforms, Inc. has actually registered to do business in Nevada. And I understand, and with the state of Nevada. So Meta has made filings with the state of Nevada in order to conduct business here. And while that's not dispositive under our precedent, it certainly is acknowledged as something to put in the court's consideration. So to say that Meta has not purposefully availed itself of the privilege of acting in Nevada when it has registered to do business here, does do business here, and is beyond the pale, frankly. And the other part of the first purposeful availment analysis is whether Meta is causing important consequences in Nevada. The evidence, which is cited throughout the complaint and uncontested, is clear that Meta's conduct directed toward Nevada is causing important consequences for minors in Nevada. And that is why the state of Nevada brought this action in the first place, because of the important consequences of Meta's conduct on the lives of Nevadans. Now, whether the cause of action arises out of the defendant's Nevada-related activity, also a resounding yes, Your Honor. We have a significant number of claims related to different design elements that Meta has intentionally added to its messenger platform that are being challenged in this case. And so I do want to take a step back. Even though we're here today on a motion related to just one of those design elements, end-to-end encryption, for purposes of the court's personal jurisdiction analysis, the court needs to look at the entire complaint, not just the end-to-end encryption. And that dovetails with the causation of important consequences that I just mentioned. It's all of the design elements and all of their impact. And those allegations and those aspects of Meta's messenger platform are specifically what's at issue in this case. So these claims arise from Meta's direction of its business in the state of Nevada. Meta has not stated how many users it has in Nevada, but the state has alleged rough information based on available evidence. So, Your Honor, I believe the evidence does show that Meta has purposefully availed itself here in Nevada, and the state's claims arise from those same contacts. And finally, we didn't hear much, or maybe anything, from Meta about the third prong, about the reasonableness of exercising jurisdiction here. But that third prong, the burden is on Meta to make a compelling case. And that's from the Piccoli case from 1995, that Meta has not met its burden. It has not even attempted to meet that burden to show that jurisdiction in this case would be unreasonable for the court to exercise. So, Your Honor, I'm happy to address anything else, but I think our papers are strong on the case law. Meta tried to distinguish the Keaton case, but I would direct Your Honor's attention to the GoDaddy decision out of the Seventh Circuit that applied Keaton and applied it in the context of an online business. Meta's cases that it cites to try to say that personal jurisdiction would be inappropriate, they are all cases involving just websites that put up a website and can be accessed from anywhere. That is vastly different from what we're talking about here today with Meta's Messenger platform, with more than 1 billion active users worldwide, many of whom are in Nevada. So, and interact frequently with Meta, enter into user agreements with Meta before they download and use the application, and get notifications from Meta on their application. There's many advertisers in Nevada who work with Meta. So there is a large impact from Meta's operations in Nevada, and clearly it would not offend the standards of the U.S. and Nevada long-arm statutes for the court to exercise jurisdiction over Meta here. Happy to answer any questions the court has before I sit down.
I do have a question with regards to specific jurisdiction.
Okay.
So, with regards to specific jurisdiction, your distinction between other electronic media cases is what for Meta platforms? Because you made a statement in your briefing, said same in oral argument, right? The number of users and going to terms of service user agreements. What else were you contending would qualify, right, under the specific jurisdiction prong?
Meta has registered to do business in the state. That's in our papers. They've also announced plans to build large property here. So they have strong connections with Nevada. It's not just a passing connection like a website that could be accessed by someone. And that is, I believe, all of Meta's authority to avoid personal jurisdiction for an online presence. And the cases we cited in our reply brief, Your Honor, say that just because a business shifts to a digital presence versus a physical presence does not change the analysis, doesn't allow them to escape personal jurisdiction. And thank you to my co-counsel. The cases that Meta cites as authority on a lack of personal jurisdiction involve companies that had static websites where users just log on if they would like. And Meta is not like those website operators. It actively recruits users and has algorithms to connect users in Nevada with other people elsewhere. So it's actively attempting to gain additional users within the state of Nevada as a matter of course of its business.
Okay. And raised both in the pleadings and in the oral argument that even the fact that there is X number of users, right, and that there's the terms of service, that does not still fulfill the specific jurisdiction requirement because it does not relate to the actual claims at hand. That's kind of where I was trying to get your position on that. I mean, you all seem to agree the number of users, that there's terms of use, but Does it relate to the claims at hand?
It does relate to the claims at hand, Your Honor, because one of the significant parts of the state's claims is that Meta has made material misrepresentations and omissions, including getting parental consent for minors who use the Messenger platform. And so they have not disclosed material information, and they've disclosed materially false information through the user acquisition process, which includes the agreement. We've tried that in our complaint. So we've got material misrepresentations and omissions that are at issue in this case and tie into their user agreement and what they notify people of before they permit people to set up accounts.
Which ties into the other argument with regards to the difference between allegations and evidence. I know you generally said that you've got points of evidence in your complaint. Are you asserting that there's points of evidence to the specific conduct of Meta? To the specific jurisdiction problem, again?
We have paragraphs 81, 82, 83, and 84. And I believe 81 through 83 all cite to various evidence. And then we have a Nevada Deceptive Trade Practices Act claim that ties in with the sale of goods or services, and that connects to all of these allegations and Meta's conduct within the state. And Your Honor, I would also say, if the court has any questions in other matters, parties in the plaintiff position who are facing this type of motion often ask for personal jurisdiction-related discovery. We have Meta witnesses here today who could be asked questions related to personal jurisdiction. I don't think it should come to that. I believe there's more than enough in the record for the court to make a ruling on this right now, and we could proceed. However, there are numerous options that are less severe than simply immediately ruling that the court could never, or excuse me, that the state could never present evidence to show personal jurisdiction over Meta.
I'm going to tell you both where the court's inclined to go, and I'm going to give you each, it's not a surprise, you've heard me do this in the past, right? I mean, you both make very compelling arguments. Where I'm inclined to go is I'm inclined, and you can see my questions were targeted on the specific personal jurisdiction prompt, right? And as you all know, in Tricarchi, specific jurisdiction is proper only where the cause of action arises from the defendant's contacts with the forum, and that's cited to Fulbright and a whole bunch of other cases that predate that. And that's one of the versions of Tricarchi, not the most recent one. That being said, the court is really thinking that there does need to be some type of discovery on those contact aspects, because realistically, I think general jurisdiction is there. I do have a question with regards to specific personal jurisdiction tied to the distinction between the allegations versus the evidentiary components contained in the allegations in the complaint versus whether or not, as raised by Meta, the actual allegations in this complaint relate to the conduct of Meta. And the distinction, as you all know, one says certain of the cases do deal with digital media in the generic sense, and the other says, well, it's a static website. So that's where the court is inclined to go. I think I can do it today if you all want to. I mean, I appreciate a better courtroom full of people that spent your time, right, and your client's resources to be here today. I think it really can be if the parties wanted to, you know, a little bit of witnesses with examination and cross-examination. However, I'm also cognizant that somebody may have a different viewpoint, so let me hear in a few moments each of your viewpoints. And do not take my inclination that realistically I've decided one way or another, because it is where it is at this juncture, based on what I've heard thus far. So, Councilor Mehta, you got to go first, so I'll let you go first on this one too.
Thank you, Your Honor.
So the simple question is, do you want me to rule now, or do you want me to allow some personal jurisdictional discovery? And if you want personal jurisdictional discovery, is it a today issue that we should have a couple witnesses, if the parties want to, set forth their various positions with examination or cross-examination, or are you requesting some third alternative? That's the same question I'm going to ask both sides. Okay.
Thank you, Your Honor. But we do not believe it would be appropriate to proceed with personal jurisdiction discovery today, because the witnesses we have are not the ones that would be properly presented by Meta in relation to the question of its activities in the state of Nevada. So I don't think it would be appropriate for us to be asked to put these witnesses forward on that topic. They were here to testify on other subjects today. If there's going to be jurisdictional discovery, and I understand the court's point, and I hear the court, we think that needs to be done in a more orderly fashion than just today on the fly. And so I would submit, Your Honor, that the proper course is to engage in this jurisdictional discovery and then renew. There is a motion to dismiss that we have filed that's pending, and the motion to dismiss raises the personal jurisdiction issue. The state has asked for 30 days to respond to that personal jurisdiction motion, as well as our other arguments to dismiss the complaint. It seems to me the most orderly way to proceed would be to suspend now, pursue the jurisdictional discovery, and it can be taken up in relation to the motion to dismiss.
I'm going to ask you the question about counsel, if you don't mind.
I'm sorry.
No worries. I did mention that there's another case before this department, right? And each case is different, each case, and you have your reasons, and I appreciate that part of the questions with specific jurisdiction. This court's very familiar with the distinction between a trademark case and a case involving certain encryptions, right? What I do have to ask you is, should the court, from your position, I'm not saying whether I have or not, my first statement was really just a disclosure because I wanted to make sure everyone was on the same page, right? So that everybody knew that I already had another case, and I knew counsel for the state did because their counsel in that other case. I knew Meta Platforms, your client, knew about it because they're in that case as well. Whether you specifically knew about it, I wasn't sure. Although I presumed you all talk among each other.
Yes, sir.
I've been in private practice.
We do sometimes.
Been there, done that, okay. But can you give me a brief explanation of if an entity, right, does the extent of business that Meta Platforms does, right? And FYI, I'm going to interchangeably use the term Meta and Meta Platforms during this hearing. Please do not use it in your other case, okay?
We will not, Your Honor.
Okay, from either side, I just, sometimes it's quicker to say Meta versus Meta Platforms. And I already have an agreement with the other case, it doesn't matter if I say either one, so, okay. That being said, should the court take into account the positions that have been articulated to this very court in another case on the personal jurisdiction issue? Or should I just completely disregard it because it's apples and oranges or whatever phrasing you would like to say, trademark and encryption?
Well, Your Honor, I do think the personal jurisdiction question is entirely different. As I understand it, in the other case, Meta Platforms Inc. did not contest personal jurisdiction.
That's why I'm asking. Because I saw you did contest it here. Realistically, yes. That's a practical question.
And I think it really frames up exactly the question the court was asking the state about how do these claims arise from Meta's alleged contacts with the state. And I think that's the reason it's different, because as we look at this question of personal jurisdiction here, the claims asserted by the state don't arise from Meta's connections with the state of Nevada. That's different from the question that might be presented in a trademark case, where the whole question is, are you using the trademark in the state? And it feels quite inherently bound up with activity in the state. So I think conceptually it's quite different, and it really frames up this point. Do these claims arise from Meta's alleged contacts with the state? And I think it's exactly why it's a different issue for the court. And I think it helps explain why you have two cases with very different positions being taken in relation to this question of personal jurisdiction.
Okay, my next question is going to be, they have a motion for preliminary injunction on for today, right? So why should the court wait until a subsequent filed document, i.e. a motion to dismiss, which is not set to be heard until March 16th? Defer, and I get it's kind of a two-pronger, because in this specific case, right, you all were here on February 26th, the first date for the hearing. And I appreciate we went through a lot of procedural aspects, and that was decided by agreement of the parties to come back today. So shouldn't the state of Nevada get their day in court today on their preliminary injunction, or you think, why should the court postpone it to the 16th when as you're requesting. If you can just clarify that point, because,
Yes, Your Honor, I understand.
and seriously, whoever- I do believe we asked you all, before we went on the record, to please ensure to have all electronic devices off, please, unless you have a media request, because in fairness, each party probably wants to have a nice clear record, and we want to make sure it happens, so if you haven't done it before, please do so. Thank you so very much. Go ahead, Counsel.
Your Honor, the point I would make, and I'm sure the court has seen this in our papers, the state knew about this announcement by Meta that it was moving to default end-to-end encryption as of December. The state has not rushed this. The state waited for months to bring this issue forward. Meta announced in 2019 it was moving to default end-to-end encryption. This has been known for years. So the idea that there's some rush to immediately address this, I think is just incorrect. And so it does seem to me there's a question of personal jurisdiction. We submit the court does not have authority to hear evidence from our witnesses in relation to a case if it lacks personal jurisdiction. So I think as a matter of good order, sensible procedure, particularly because there is a motion to dismiss coming at the court fairly soon, that would allow for the time to be taken as needed for personal jurisdiction discovery. We don't think the state can establish it, but we would give them the chance for that discovery. And it feels the court's going to have to resolve that personal jurisdiction issue in relation to the motion to dismiss in any event. But I think today the court's problem is, as a matter of due process, we submit that it can't hear the evidence unless it has satisfied itself on personal jurisdiction. That's why I proposed the solution of suspending the proceedings, but I think it would be very difficult for the state to make a meaningful argument that the delay is harmful given the state's own delay in pursuing this. After the announcement was made in 2019, then the rollout began in December. So those would be my points.
No, I do have one last question, and that's pure timing, right? I'm understanding what you're saying hypothetically, but let's walk through. Technically, under discovery rules, the court would have to grant discovery right before there's a responsive pleading. So would there be an objection there? And second, the timing aspect today is, as we all know, is March 20th. The next hearing is set for April 16th. So if the court were to adopt your proposal, we'd have to be expedited discovery without either side saying that they need the 30 days, right, to do a response. Is that going? I do appreciate that I'm asking a prospective question, but I have to see if it's a reality, because if it's going to be, well, Your Honor did this, but guess what? Now we don't need to respond to discovery for 30 days. Now you need to put that hearing off, and then we go down that type of path. You can appreciate. I'd rather know all the outcomes as much as possible in fairness to all parties to address it. And if you say, guess what, Your Honor, you have to wait and see, that's a fair response, but maybe not the response.
I don't think it would be consistent with the position I'm taking with the court for us to stand on a 30-day time period to provide objections and slow down the train that way. I think, subject to constant consultation with my client, I think we'd be prepared to move ahead and allow the state this jurisdictional discovery, and then I think it can be teed up for the court in the April 16 hearing, which feels quite orderly to me compared to trying to do it today.
Appreciate it. Thanks very much.
Thank you.
Counsel for the state, go ahead with your position, please. If you want to. As you know, this is optional, additional. So.
Absolutely want to, Your Honor. I appreciate the opportunity. I guess I try to take notes on the court's questions. I'd like to make just a couple of comments that I think bear on the court's questions, and then also answer those questions as best I can. I believe I said this before, but I want to make sure it's clear. Meta has told Nevadans that end-to-end encryption is safe and secure. The state has alleged and presented substantial evidence to the contrary. Meta has stipulated to allowing the court to consider the amicus brief from Child USA and the National Center of Sexual Exploitation, and they are strongly against end-to-end encryption for children. So to say that there is no evidence, and that amicus brief quotes the FBI director, Christopher Wray, and he explains how end-to-end encryption prevents law enforcement from identifying and rescuing children who are suffering horrible abuse. That's the reality of end-to-end encryption for minors on Messenger. Meta has not disclosed that type of information to its users. That is a material omission and misrepresentation directed at Nevadans and all users. That is enough to go forward with this case and find personal jurisdiction. Now, Your Honor asked about the discovery. The state would be happy to proceed if necessary and ask Meta witnesses today jurisdictional related questions. It's in our brief, in our reply, and it's only in our reply because Meta didn't raise personal jurisdiction until its opposition. But on page 9, lines 16 and 17, we asked, if necessary, for expedited discovery to resolve the personal jurisdiction defense. Meta knew that this was an issue. It is known this is an issue since February 20th. This was in their initial brief they filed on February 21st. We were here for a period of time on February 26th. The state accommodated Meta and agreed to take the TRO hearing off. So the state objects to further delay. Meta has had plenty of time to file a motion on OST raising its defenses. And to say that we can't go forward here today just falls right into Meta's hands. And they would want nothing more than to get further delay. And counsel says there's no rush. This is a 2019 announcement. Well, the state disputes that just Meta announcing that it plans to maybe do something in the future is even actionable, first of all. But the state, in December of 2023, was actively involved in retaining my firm and my co-counsel to assist with this case. And we prepared a lengthy, detailed complaint and filed it 1 month later. So to say that the state has been sitting around doing nothing and there's no rush because the state has not acted expeditiously is false. Also, I would like to hear Meta tell the children being abused that there is no rush to this issue. I would like to hear Meta tell Investigator Gonzalez and Mr. DeFonseca sitting in the back of the room that there's no rush to this issue. When they serve search warrants on Meta that are signed by courts of lawful authority in the state of Nevada, and they get virtually useless information, is the testimony that the court will hear, and it's already in the record. I would like to hear Meta say that there's no rush to those people. There is certainly a rush from the state's perspective, from the perspective of parents and children who are being harmed by end-to-end encryption being used right now by children in the state. So there is certainly a rush. And if Meta wanted to delay this case further and assert its personal jurisdiction argument, it could have done so in a different way than an opposition filed 2 weeks ago and now asking to delay this proceeding even further. We have dozens of people in the courtroom. Meta is prepared to proceed. I believe there's more than enough information before the court and evidence. We've met our burden to show personal jurisdiction over Meta. We should proceed without any further delay. As far as the court's other questions, I'm happy to answer them if you think they're still germane.
They are.
Okay.
Okay. One, right, the citation in the amicus brief, right, to FBI Ray, and that is W-R-A-Y. Isn't that from a 2019 presentation that he did?
It is.
So that's one of the reasons the court was looking at, right? This is not something that is a new issue, right? And in the law review article that you cited, I believe, excuse me, they cited, I think it was 2022, if my recollection is correct. But that's in no way minimizing the issue, but how can the court, I've got a motion to dismiss set for April 16th, right, with the right under our rules for them to be heard on that motion to dismiss. The failure to file an order shortening time doesn't preclude the court from having to hear a motion. And in fact, as you know, sometimes people send regards to order shortening times, right, the shortened times. And you got it in this case, right? You quoted their breakneck speed in your reply. Okay, they use breakneck speed, right, in their opposition to your motion for preliminary injunction. So, and you're familiar with a plethora of Nevada Supreme Court cases, right, with regards to the personal jurisdiction and to personal jurisdiction discovery if there's some issues. And here, what the court has before it, right, I mean, it's a very, very detailed complaint, okay? But does the court actually have before it the time and the nexus between the actual allegations in the complaint and what you assert as the evidentiary support therein and the causes of action as tied to the personal jurisdiction issue?
Yes, Your Honor, we have Meta's white paper. It's Exhibit L to Ms. Peterson's declaration with their opposition brief filed on March 7th. That is Meta's position statement on the safety, purported safety of end-to-end encryption. And it is replete with statements that are half-truths that do not disclose the actual harm to children and others from end-to-end encryption and how it creates a virtual black hole. And when bad actors get connected with children and get them into Messenger with end-to-end encryption, no one, not Meta and not law enforcement, can discover it or stop it. That's what Director Ray was talking about. He was not talking about Meta specifically or Messenger because it wasn't enabled yet. There were other platforms where this was happening. So it is a new issue. Meta did not launch it until December 2023. That is only a month and a half or so before, 2 months before the state filed its action and moved for a temporary restraining order and asked for a preliminary injunction that we're here on today. Meta's public-facing documents and statements, including testimony in front of the U.S. Senate, are misleading to the public about the dangers of end-to-end encryption and its platforms in general. Those public statements that contain material omissions are directed to the entire user base of Meta, which includes Nevadans. And the state of Nevada has statutory authority through the Attorney General's office to bring this action to enforce Nevada's statutes on deceptive trade practices that specific in NRS 598 that specifically relate to material misrepresentations and omissions related to the sale of goods and services. That is what Meta has done. That has a direct nexus to the injunction hearing that we've briefed and that we're here today to address. And that is sufficient.
Okay.
Yeah, Mr. Jones handed me a note. I'll just make the comment. This is in our briefing as well, but Nevada has a specific criminal statute. We're not alleging Meta has committed a crime, but Nevada also has a statute referencing the use of encryption in the commission of crimes and making that illegal. So the state of Nevada has already spoken from a public policy standpoint that encryption being used in criminal activities is not permitted. And these are the sorts of issues that the parties have briefed, are ready to address with live witnesses and exhibits to show what Meta knew and what it did not disclose to the public. Those are the types of omissions that are outlined throughout the complaint and that affect Nevadans and have more than enough of a nexus to support personal jurisdiction and move forward today.
I was going to ask another question straight out of Trent Carchi. So I'm going to read you a paragraph right specifically on the analysis of specific personal jurisdiction. I'm going to ask you a question on problem 3. And since this was quoted in the pleadings, it's appropriately asking the question across this case. In analyzing whether specific personal jurisdiction exists in a tort action, courts apply the, quote, effects test, end quote, derived from Calder versus Jones, 465 U.S. 783, 1984, which considers whether the defendant, quote, 1, committed an intentional act. Well, we already answered the question on that. 2, expressly aimed at the forum state. 3, causing harm that the defendant knows is likely to be suffered in the forum state, end quote. Citation to Picote versus Weston 780 F3D 1206 in the Ninth Circuit 2005. The internal interpretation marks and citations admitted. The reason why the court was asking a lot of the questions right on specific personal jurisdiction is because the assertion with, looking at the causes of action and then looking at the facts that are supporting the causes of action, and then going to that third prong and looking at specific jurisdiction under the effects test is, what are you contending the court has that the defendant knows is likely to be suffered in the forum state, right? Versus you assert that they did cause harm, right? But I got that knowledge aspect. How can I have that knowledge aspect currently based with a complaint in what I currently have before me, even taking into account maybe it's correct, right? I've looked at all the dates, looked at all the presentations, looked at the different issues, and this is not a brand new issue as of December 2023. It's new to this court when this pleading was filed, but how do we have the intention, right? The intent component based on what I currently have.
Thank you, Your Honor. Happy to address that. You have a statement from Investigator Anthony Gonzalez under penalty of perjury before you.
In which pleading though? Which part are we doing from Gonzalez? Are you doing it from the motion or from the reply? Because as you know, I have a different nuanced issue.
It's from the motion.
Go ahead.
It's from the motion. And he reported in the past 12 months, the state of Nevada has received 721 cyber tips related to the Meta platform. Okay, and those are tips of harm that's occurring and touching the state of Nevada. So that is actual evidence you have before you that's not objected to in terms of being attached to a reply, we can address later. But, so we have those cyber tips. We have also...
Can I pause for a quick second? Do I have anything that says that Meta knows about those cyber tips? See, I'm going to the knowledge component. It really is why I'm heading towards the potential aspect or the jurisdictional discovery under the specific jurisdiction.
They come from Meta. The cyber tips come from Meta. The ones that relate to their platform are coming from Meta. So they...
The challenges, where I'm going is, they would know the number of subpoenas they're getting, right? They know the number of tips, right, and inquiries they're getting. But I'm trying to have an understanding based on what's before me about whether that shows a knowledge of harm committed in the state versus just knowledge of what's the tips, right?
The
knowledge
cyber
of the
tips.
actions versus the actual, right, harm. Go ahead, please.
Sure. The cyber tips from Meta are being routed to the state of Nevada's Internet Crimes Against Children Department. That's the evidence before the court. So they know that these potentially involve crimes against children occurring on their platforms. We don't have the precise number of search warrants that Meta has received from within the state of Nevada, but we do know from Inspector Gonzalez that at times he has personally obtained search warrants, searching to investigate potential harms occurring in the state of Nevada. You have Meta's white paper, Exhibit L, to Meta's opposition on March 7th, stating that they understand these issues with law enforcement, and they understand that with end-to-end encryption, they can no longer report any of those cyber tips unless a user specifically reports a bad actor's conduct or contact with them. So they understand that end-to-end encryption in their own white paper, updated September of 2023, which is also very recent, they are telling the public that this information cannot be obtained by law enforcement. It can't be self-reported by Meta any longer on any end-to-end encryption messages. So Meta knows of this potential harm. They know, and they researched it for a period of time. And I don't want to get into things that might be confidential, but there is substantial evidence that Meta understands and understood all of these things. There's enough information in its public-facing white paper on the purported safety of end-to-end encryption and how that is not borne out by the facts. So those material misrepresentations go directly to its knowledge of the harm, its inability to present law enforcement with any more cyber tips of child sexually abuse materials, CSAM, that it finds on its platform. It cannot identify that any longer with end-to-end encryption. It will not be getting, providing these reports to the National Center for Missing and Exploited Children. Investigator Gonzalez, this is on the reply, so Your Honor may want to ask us this bit of evidence, but Investigator Gonzalez stated in his second declaration that the state has received less CSAM reports since December 2023, when Meta moved forward with default end-to-end encryption. So we have that evidence as well, and Meta would certainly have knowledge that it's providing less CSAM reports to law enforcement in Nevada. So knowledge of harm, they know the harms caused to minors from the use of default end-to-end encryption. They've known it for quite some time. They ignored it, moved forward with end-to-end encryption as a default, including for minors, and told a very different story to the public about how end-to-end encryption would still be safe, and don't worry, and we'll still work with law enforcement. But they did not disclose all of the negative things that come from end-to-end encryption with children. And Mr. Jones passed me a note. I think I covered this, but with Meta repeatedly sending cyber tips about harm to Nevada children or harm occurring in Nevada related to children, that's an admission of their knowledge. And that's the 721 cyber tips from Meta was just in the past 12 months. These have been coming for years. They have known that these harms are occurring in Nevada and ostensibly complying with their mandatory reporting obligations when they become aware of these things. And the evidence shows that those cyber tips are important for law enforcement to identify situations of abuse of children and other crimes occurring in the state that the investigators can then investigate, hopefully prosecute and stop. So I believe Meta has more than enough information about the harm under the prong that the court read.
I think in fairness, since I didn't ask opposing counsel, you know, I'm going, so I
I
didn't
do.
ask opposing
I'll sit
counsel
down.
the tricarchie question. I think in fairness, he gets to respond when he's really last. Okay, counsel, I'm going to focus you only on the tricarchie question, right, the third prong, the knowledge of the harm, because that's a question that I did not ask you, and give you an opportunity to respond if
Yes.
you wanted to. So,
Yes, Your Honor.
do you need me to repeat it, or do you know what I was asking?
I did have it in mind as the court framed it. If I could ask the court's indulgence, I'd also like to speak briefly to the second prong, because as I heard the court read it off and I studied that tricarchie case, the second prong is whether the conduct was expressly directed at the forum state. There was nothing in the state's response that addressed any activity expressly directed at the forum state. And so I think that's a separate point I just wanted to flag in addition to the knowledge issue. I don't think they can establish knowledge, and just to be clear on that, Your Honor, we don't agree with their rendition of the fact that they're relying on allegations of complaint. And the case law is clear in Nevada that allegations of complaint are not evidence. And
Aren't they also relying on, as phrased by Mr. Gayan, what, giving an offer of proof of what in a declaration, what would be testified to by Mr. Gonzalez, right, in the 720 cyber
so let's
tips that then has gone down. Go ahead.
I'm sorry, Your Honor, I
Yeah,
didn't
no
mean to
worries.
interrupt the
No worries.
court. On the cyber tips, this takes us back to the question of whether the claims arise from the alleged connections with the state. The claims are based on alleged compulsive use of Meta services and alleged misrepresentations about the safety of Meta services. It's not cyber tips. The claim is not around cyber tips. The claim is based on the features of meta services. And so I think they fail on the arising from standard of Triparici. And so I think that is really a critical point to focus on. If we take all of what the state said as correct, all of their argument is they're reiterating elements of their claim, but they're not showing that those claims arise from Meta's alleged connections with the state. And so they fail on that second prong of arising from. Even putting aside this question of knowledge, I don't think they can prove knowledge in relation to the harm that's being alleged in the complaint, which is compulsive use. But I'll put that to the side. They haven't shown the court anything in relation to conduct, quote, expressly directed at the state, which Triparici lays out as one of the prongs for this purposeful availment. So as I understand it, it fails both pieces. It fails the purposeful availment, but it also fails arising from, because they've not shown the court that their claims arise from Meta's alleged connections with the state, which continue to be limited to alleged conduct involving advertisers or alleged conduct involving the terms of use, and those are not the issues in the case.
Counsel, you've done a very, very nice job of focusing on the aspects you want to. I believe the state was focusing right on what they were saying is the misrepresentation concept, right? With a separate cause of action, and they were trying to, I believe, Mr. Gayan was contending that we utilized the white paper, right, and the other documentation that he referenced, that there was affirmative statements that we quoted Mr. Jones, his colleague, right, saying that that's an admission that there's a knowledge of that the actions would be A to the state of Nevada, and appears to be contending that that means that Meta knew that it would have some impact and just wasn't accurate on the expense of impact. You know, whether it's 50, 50, 70, 30, 90, 10, whatever. They didn't give me any numbers, but you know what I mean, that it was not a correct recitation of all of the impacts. And so I'm hearing what they're saying, I'm hearing what you're saying, but are you saying it doesn't apply to the
Your Honor,
cause of action in the case?
yes, Your Honor, I think, so let's take the misrepresentation allegations. The allegations are Meta misrepresented the safety of its services. We think we can beat that factually, but we'll put that aside. The suggestion of a misrepresentation has no suggestion at all, no allegation of specific targeting of Nevada as compared to everywhere else in the country or frankly around the world. So it can't work for an internet service provider to say you engaged in global activity and therefore we have jurisdiction in the state of Nevada. I think that Nevada Supreme Court case law is quite clear that that's not enough to establish specific personal jurisdiction. And so there's no showing here, even if we accept their arguments around misrepresentation, there's no showing of any specific targeting of Nevada as compared to Meta's activities all around the country or the world. So I think this is where they run afoul of the specific jurisdiction analysis, because they're not presenting any conduct purposefully directed at Nevada. And in relation to internet service providers, social media services, the case law is really very clear and strong that you have to look at something that's more purposely targeted than merely the fact that they're operating social media services all across the country, or else the result would be that they're subject to personal jurisdiction in every state, and that is not the law, and the law is clearly rejected by it. So that's why I go back to the point, for these purposes today before the court, we won't fight over this question of misrepresentation, but it doesn't help them on personal jurisdiction because they're not showing the purposeful targeting to the state.
Should I pause for a second? Oh, no, sorry. I thought you was heading the other way. I thought you were going to get past a note as well. No worries. Okay, then I promise the state last word, and go ahead, counsel for the state, you get last word.
Your Honor, I'll be brief. I think you've honed in on the issues from the state's perspective. I think the best way to sum up Meta's personal jurisdiction argument is that we just heard is that because it targets everyone in the country, then it can't be sued anywhere, that it wasn't specific to anyone. Well, it was specific to Nevada. It was specific to the entire country. And they wanted everyone to hear and rely on those representations and misrepresentations and continue using their services and not delete their applications. That's what they wanted. That's why they made those representations. That's why they continue to permit people in Nevada to use their extensive services. And there's clearly personal jurisdiction here for all the reasons we've said, and we would ask the court to rule so and allow us to proceed today.
Here's what the court needs to do. I think the directive in Tricarci is clear for this court. We do need to do some jurisdictional discovery in order for pure limits to stick. But realistically, the court's found that there's general jurisdiction. Okay, but I do only that Tricarci's effects test and the specific articulation of each of those prongs that does need to be fully flushed out for this court to be able to make the determination on specific jurisdiction. I think the Nevada Supreme Court, and well, it's that case, I can cite you some unpublished case from the Nevada Supreme Court and some other cases. As you know, personal jurisdiction has recently come up before the Nevada Supreme Court on a multitude of different times. And generally the concept has been, other than one case I can think of on it, has been to allow some personal jurisdiction discovery before the court makes that determination. Because otherwise what we've run afoul of is that what would be moving forward with this case. Realistically, you're going to need to address it now or later anyway, and have to address it in April. And I really find that it is the appropriate first step to make sure we're clear and we can get to the merits of the issue. I do not find that, and I can do it sooner than April 16th. The reason why I was saying April 16th is because that is currently the date that you already have a motion to dismiss. It really allows, it's less than 30 days, so it allows time to get some jurisdictional discovery. At least I've heard from Meta so far that you're not going to all of a sudden say you have to have 30 days, right, and put that date off. It allows to get that clarity so that we don't have the issue of whether it's allegations versus evidence, and you have the clarity to walk through. Each party does directly with regards to the effects test set forth in Tricarci with as it applies to this particular case. And I am very appreciative of the ongoing activity argument, and I am completely empathetic with individuals that are impacted as asserted in the complaint. But once again, we don't want to have an issue that this is going to move along a path that's going to take a lot longer time for you all to get to your preliminary injunction versus having this short time period to allow some jurisdictional discovery in a very discrete issue. Like I said, it's only on the specific jurisdictional issue will allow this case to move forward in its proper course in a very quick and timely manner. Now, I will tell you that I can hear it earlier than the 16th if both parties want to. I really was trying to tie it to a hearing that you already had on the very topic so that it was consistent and to be done. That realistically, I hear the state saying that Meta could have done an OST. Well, if you want to shorten some of your time periods to response, and you want to get me, I can do it the week before if you all wish me to do so. But that really would be by you all's agreement. I'm trying to give time for you to meaningfully engage in some of this very, very limited, discrete discovery and get where you need to be. So the question becomes, what do you all wish to do? Because there's going to be some very limited, like I said, on this discrete issue, jurisdictional discovery. I can hear it on the 16th, I can hear it before then, and I can hear it after then if there's something that meets the parties' needs better. So let me hear from each side, counsel for the state. It's your underlying motion, which we were going to get to today, but we still have some other things to go forward. Go ahead, counsel. What's your thoughts?
Your Honor, Michael Gayan for the state. We certainly don't want it to be any later than April 16th. I guess one opening comment is it's baffling to the state that Meta wanted to press this issue today, knew we wanted discovery, that there were any concerns and they did not bring a witness prepared to discuss it, knowing that further delay would prejudice the state, so.
But counsel, you understand the court has the situation the court has. There's no subpoenas that anybody has told this court about which required the attendance of anyone, right? And as you know, preliminary injunctions, unless there's subpoena, it's voluntary attendance. So the court has to address the actual circumstances before it.
In no way disparaging the court, I'm just saying on February 26th, Meta stipulated to have an evidentiary hearing today on all issues in the party's briefing. They raised personal jurisdiction and did not bring any witness to address the issue, so that's disappointing to the state, but we'll certainly proceed. Our request would be to be allowed to serve targeted written discovery, shorten Meta's response time to 7 days, and permit a 30B6 witness and up to 2 additional depositions as needed, depending on what we get in response to the written discovery. All on shortened time.
Your Honor, just one other issue. We haven't obviously had time to really confer on this, but there's this motion to dismiss hearing, but now we're going to have a motion for a motion related to personal jurisdiction. Then that motion to dismiss hearing then probably needs to be kicked out. We can focus on the motion for the motion on the jurisdictional issue on the 16th, kick out the motion to dismiss another 30 days. We shouldn't be here. We had an agreement. We shouldn't be in this impasse. And I understand the court needs, I'm just pointing out that this is, Mr. Gayan, I think, is being very kind in his words about being disappointed. This put the state in a very, very improper position. We shouldn't have been in this position. This was something that clearly they were planning to do, and so they need to now then, if they're going to do this to us, they need to step up and make those witnesses available, we believe, within a week's time, as well as having responses to the discovery within a week's time, so that we can then get a brief on file with the evidence this court needs, apparently needs to be able to make this determination, and get this all done by the 16th. And then we can deal with the motion to dismiss. But they brought this issue. This is the choice they made, and now have forced upon not just us, but the court. So then they need to accommodate us and the court. Yes, Your Honor. One other option we have today, we've got people that have come in from all over the country, as you well know.
That's why I'm perfectly fine to do it today. But when I get told realistically that there aren't witnesses here and there's not a subpoena, and I quickly tried to go back and look at the transcript, I did not see a specific representation on an agreement to bring, basically the personal jurisdiction issue was brought up to this court on the 26th, right? And I don't know what behind the scenes agreement between the parties, not in front of the court. So as you know, I can't hold people responsible for something that in open court wasn't agreed to under EDCR 7.50, a stipulation or a court order. And that's really where the court's situation is now, right?
So, Your Honor, let me, I guess, make one proposal here as well. Sure. Since we've now been put in this position unwillingly, and we think that's actually contradictory to what the agreement of the parties was when we waived our right to go forward with TRO, they do have 2 witnesses here. We'd like the opportunity to voir dire those witnesses today in open court on the issue of jurisdiction. Now, they may not be able to establish the jurisdiction that we believe exists in this case, but we have now the opportunity and the circumstance. And so, since we've been put at a very significant disadvantage by conduct of Meta, we would then think that that would be an appropriate accommodation under the circumstances. We would ask, of course, indulgence to allow that to happen, because it may actually obviate the need for further hearings on this matter.
Counsel, you brought people here. Everyone knew it was going to be an evidentiary hearing, right? By agreement of the parties. In fact, if you recall, you all spent a few hours, right, going back and forth, shuttling between the anteroom and the jury room, right, coming to a specific agreement. And this court's aware of what the agreement was made in open court. Obviously, the court's not aware of what was done when the court was not there. So, any reason we shouldn't just go forward to see what these witnesses' viewpoints? You brought people from Meta, right, presumably for an evidentiary hearing. Shouldn't they have an opportunity to examine them?
Your Honor, if I can make a few points. First of all, we agreed there would be a hearing today on the motion for preliminary injunction. As we see it, there's fundamental legal flaws in the motion for preliminary injunction that need to be addressed before the court can hear evidence, as I've spoken to previously. In relation to this question, the state sounds as though they're agreed. The state carries the burden of establishing personal jurisdiction. We had expected the state to demonstrate why it thought it had personal jurisdiction. We're entitled to challenge personal jurisdiction. The state bears the burden. It's not on us to, and so, but in relation to the specific question of voir dire of our witnesses, we think at this point that these witnesses are not the witnesses that the company would present on the question of personal jurisdiction in the state of Nevada.
But counsel, and listening to what you're saying, okay? And I have to go back to what was said here in open court back on February 26th, right?
Yes.
There was agreement stated in open court, and the term evidentiary hearing and witnesses was going to be here because, you know, what said, you all can bring whoever's appropriate. I would have to go back and read every single word of the transcript a third time. I read a couple times in preparation of today's hearing, but my top of the head recollection, are you going to say that you said that there would be a personal jurisdiction issue on February 26th? When I say you, anyone on behalf of Meta?
We had reserved, as the court recalls, we wrote that paper in a day. We had reserved the question of personal jurisdiction in that TLO opposition. We had not by any means waived this question of personal jurisdiction. As we then received the state's motion, as we looked at those papers, it was very clear there's a fundamental question of personal jurisdiction, and the case law in this state is also very clear that the court lacks authority to proceed if there's not personal jurisdiction in relation to a preliminary injunction hearing. So it seems to me it's logically part of the question, is there an evidentiary hearing? The threshold question is, can the court hear evidence?
The evidence being sought right now, counsel, right, is that you brought witnesses here, right, for purposes of, to address all the issues, right, in the motion, the opposition, and the reply. And so if you brought witnesses to address the issues in the motion, opposition, and reply, then presumably those witnesses would be able to address issues in the motion, opposition, reply. And one of the issues, as the state has articulated in the opposition, right, was bringing up the personal jurisdiction issue, which is why I understand they requested to voir dire said witnesses that are here. So that's what, you can appreciate what the court's kind of struck. I'm trying to unravel because I normally don't have people bring witnesses if they don't relate to the underlying motion, right? And so,
Yes, Your Honor, I'm sorry.
and this isn't like it's a specific issue that would involve someone's specific knowledge, right, of a discrete particular time that only maybe one or two people were involved in, right? This is meta policy, and as a very sophisticated company, we all have, wow, filled up almost all of our seats on the right-hand side, right, in the courtroom. To say there's no one here that you brought as a potential witness, because if we move forward with the preliminary injunction hearing, right, on the merits, you'd have witnesses that would be addressing the actions of Meta, correct? And
Yes.
so why wouldn't they be able to address it for this purpose as to it's the action, right? The states are saying the actions of Meta, right, impact the state of Nevada, and it was no one. Now, that overlaps, that issue, right, does overlap with the underlying merits of the preliminary injunction hearing, which is why, from the court's perspective, I'm not seeing the state of Nevada's request to be unreasonable or a surprise because this was set for an evidentiary hearing and the topics of the actual practices would have been a topic of the preliminary injunction hearing. And maybe I'm missing something, so maybe you can enlighten me.
Yeah, maybe I can explain that, Your
Sure,
Honor.
go ahead, please.
The only factual issue that the state presented in its papers in support of preliminary injunction related to this law enforcement question. Was law enforcement being deprived of the ability to review encrypted messages, and was that somehow an unfair trade practice? That's the disputed question factually that was raised by the state's papers. The state brought in no evidence on personal jurisdiction, none. The state's complaint is very, very thin on the question of personal jurisdiction, but it's the state's burden to establish personal jurisdiction. We did not have an affirmative obligation to come in with witnesses to respond on personal jurisdiction. What we're entitled to do under Nevada law is to raise the objection to personal jurisdiction. The state then has the burden to come forward. They've not presented any evidence in their reply papers on this question of personal jurisdiction. They skipped over that. And so it wasn't our burden to come forward with affirmative evidence that were not connected to the state. The state has a burden to show our purposeful availment with the state, and further to demonstrate that their claims arise out of those connections with the state. So that's the backdrop, Your Honor, as to why the witnesses we brought today, it's the global head of safety and the global and the head of the messenger business that's involved in the decision about encryption. It's a large company. These are not the people who would be expected to speak to these issues around the company's activities in or related to Nevada.
What, you brought witnesses that wouldn't be able to speak about Nevada? Counsel, I'm sure that's not what you meant to say.
We brought witnesses who speak about the company's decision-making in relation to safety issues and in relation to encryption.
But this is a Nevada case in a Nevada court with we've got a wonderfully shaped state, right? But that's where this court's jurisdiction is. Mine, not super long arms don't go outside the state.
I understand. I mean, we brought these witnesses voluntarily, Your Honor. They were not subject to subpoena. I agree with that. But I simply wanted to explain to the court the reason we had not brought witnesses today who would be able to speak to the company's activities in the state of Nevada, or would be able to address whatever issues the state feels are germane on this question of personal jurisdiction. We still don't know exactly what facts the state thinks it needs to establish. And my point in my argument, Your Honor, was let's take what they're alleging. They don't meet the legal standards of the Nevada Supreme Court.
We're past that, counsel.
Okay, no, but
The court's saying, I'm going to allow you to do some very limited, targeted discovery, right? The parties to address the specific jurisdiction to make sure it's fully compliant with the tri-party faculties rights, with prior citations there too, okay? And whether we focus on all three prongs, I brought up the third prong because the intent aspect really had not been fleshed out too much in the oral argument. But I'm hearing what you're saying, but I'm trying to imagine the witness that would come forward that wouldn't be in your security, right? Who would know, right? They would know how many tips, and they would know, I mean, seeing the significant overlap between the issues for the preliminary injunction and seeing the issues for the very targeted, limited jurisdictional discovery. Realistically, you all have honed in on the fact that the focus needs to be, right, what actually has happened in Nevada. That would have been the same for the preliminary injunction standard, because it's Nevada, okay? I'm licensed in more than one state, but you know, we're here in Nevada, I'm a Nevada judge. Okay?
Yes, sir.
You are licensed in various other places, wonderful. But it's a Nevada issue. So whoever was going to be speaking would have to have some information on Nevada in order for it to be relevant to the present case. It's wonderful people came, you're more than welcome to, but unless they're here in an observational capacity, if they're potential witnesses, they'd be able to have to address the claims at issue in this case, as well as which are tied into actions in Nevada, which is why it's the state of Nevada, right, is the plaintiff. So I'm hearing what you're saying, but to say that your security person wouldn't know the data with relationship to the information and the impact in the various states, is that what you're saying, wouldn't have that information?
Well, it may be, Your Honor, that we need a little more clarity from the state on what they think they need in terms of this personal jurisdiction discovery. Because this question of was Meta engaged in certain nationwide or international policies around encryption, was Meta engaged in certain generalized policies around safety? That's what those witnesses are able to speak to. But the specific questions around what activities within Meta are directed or connected or focused on Nevada, these are not witnesses who would be able to speak to that question. That was not a factual issue that was teed up by anything in the state papers.
But, okay, I'm hearing what you're saying, counsel, and the reason why the court's asking the question is because the plaintiff's the state of Nevada. It has to be Nevada. I mean, in all due respect, right, the AG's here for the state of Nevada. He's our wonderful AG for the state of Nevada, but he's not the AG for California, Virginia, Ohio, you name it, any other state in the union, at least to my knowledge. You can correct me if I'm incorrect, but usually you can't hold multiple, right, job titles of that nature. And is the plaintiff is the state of Nevada, so this is Nevada focused, right? Because that's all the jurisdiction this court has. In fact, your very personal jurisdiction argument is that I, as a Nevada judge, don't have the jurisdiction over your company. So I'm hearing what you're saying, but I'm somewhat challenging on what the witnesses would be testifying to if they weren't testifying to the facts relevant to the present case at hand, which you're here today for preliminary injunction. And I'm really not trying to put you on the spot. It's just, well, I've not had somebody say, guess what, we brought witnesses, but they know nothing about the very case that you're here at issue on, and the very state that you're here at issue on.
Your Honor, I know the court does not want me to get into re-argument on personal jurisdiction. But the point is, this is actually exactly the point about why there's a problem with personal jurisdiction here. These are national, international policies around child safety, around decisions to encrypt messages, around global international work, national work. The problem, and the witnesses are able to speak to what the company does across the country, what the company does around the world on these issues. That's the policies being challenged at issue in this preliminary injunction hearing involve the question of the company's decision to move to encryption. And that is a national or international policy, and it's exactly the point. It's not targeted to Nevada. Now, I guess the witnesses could be voir dire to say, yes, it wasn't targeted to Nevada, but it doesn't seem to me that really, if the question is, how does the state purport to establish personal jurisdiction, what facts are they suggesting they want? I just wanted to make it very clear for the court, these are not witnesses who would be focused on those issues. They run global operations within the company, but it's actually the point of the personal jurisdiction issue, is that they have not engaged in targeted activity focused on Nevada.
So then your request for the jurisdictional discovery for the court not to move forward today, what are you anticipating could be?
I'm sorry, Your Honor, I didn't.
No, it's to come about, right? If you're saying you don't have any witnesses who can address Nevada, right? And what deposition? I mean, you're telling me the individuals that are here today would not be your 30B6, is that correct?
They wouldn't be our 30B6 witness on this issue. What we would request, Your Honor, is topics from the state in a 30B6 format that would then allow us to prepare a witness who could be knowledgeable on the facts that the state believes it needs to establish personal jurisdiction. I think that's the orderly way to proceed. These are not the witnesses who would be presented as 30B6 witnesses on the question of Meta's activities in or related or connected to Nevada.
I appreciate it. Thanks
Thank
much. State, I promised you last word. Go ahead, please.
Thank you, Your Honor. I'm stunned by this comment about we target everywhere. So I think,
I'm sorry, Your Honor. Was Mr. Gayan arguing this?
no, I'm arguing this, Your Honor.
I thought he was arguing the personal jurisdiction issue.
Actually, this personal jurisdiction issue, I want to be clear, it's not even properly before the court. There was no motion filed. Counsel just admitted in open court that they raised the issue. And then they actually brought it up in their opposition. which is not a counter motion, Your Honor.
I understand.
Any judge in this courtroom, I'm sorry, I don't want to interrupt you.
No worries. Pause for a quick second. I believe Ms. Peterson is going to go back to, since you only practice in this department, something, right? The concept is, can more than one attorney argue on behalf of a particular topic? Is that what your issue is, counsel?
Yes, that's what I was trying to say, Your Honor.
Okay. What you've heard me say in the past about right, on horse one right. I'm gonna allow it here because realistically, everyone's passing notes and, you know what I mean? So, I mean, everyone's coming up and whispering in each other's ears and things like that. You're getting it from multiple rows. And I think it's the most efficient. And remember, I am hearing this personal jurisdiction before the actual motion for preliminary injunction by agreement of the state that it can be taken out of order, even though it was raised for the first time in opposition. So I think in fairness, that's the reason why I need to allow, because you don't know who is going to be addressing it substantively down the road. And I don't see really any impact versus a whole bunch of series of notes going back and forth. So even if there is an objection, I'm going to overrule it because I think that's the fair thing to do, and I think everyone's doing it de facto anyway. Okay.
I appreciate,
So go ahead, counsel.
I appreciate that, Your Honor. And I guess my thought about that was, and I appreciate counsel's comment on that. I sometimes make that same objection. This is certainly in my experience, unique circumstance where, from my perspective, they derailed a preliminary injunction hearing procedurally. And they did it in a way that is procedurally improper. Now, don't get me wrong, this court is concerned about personal jurisdiction because they have, however, even if the manner in which they brought it up was improper, because it didn't give us or afford us the proper opportunity to respond to it, I understand the court's concern. If you don't have personal jurisdiction, then this would all be for naught anyway.
And you're basically going to get a writ and it's going to all be stopped. You're going to spend a lot more time. And realistically, as you know, the Nevada Supreme Court has found, even if sometimes something's casually mentioned, depending on which case, and that this is nothing, I have no viewpoints on this, but, right, you know as a longtime practitioner that the better course of action is to address these issues right at the time that they're brought up, and then address them how they have, which is why I asked you all if you were in agreement to have this heard before the beginning of the preliminary injunction, right? It's on your list.
It is, and since they brought it up, we were willing to accommodate that to a point. And now it's taken a turn that we feel is especially inappropriate because we didn't believe they were going to ultimately, or this was going to result in derailing of the injunction hearing, because we do, in spite of their protestations otherwise. I look at it this way. If one child between now and April 16th is saved from a sexual predator, there's nothing more important than that. I don't care what anybody else says. As a public policy point, that's why we're here. But be that as it may, this court still is required, whether we like it or not, to follow certain procedures. And if you don't have jurisdiction over this case, then if those one child or more is harmed, then unfortunately the law was not able to protect them. In the meantime, I would ask this court to consider this. They have said, and I don't want to digress too much about this issue about in the personal jurisdiction, but I want to make this point because counsel raised it several times. These witnesses, by the way, which I would remind the court, they chose the witness to bring to this hearing. We didn't choose them, they chose them. And as you pointed out, so I think significantly, they chose witnesses to come here to testify on issues that by the very preliminary injunction motion that was at issue, we're supposed to be talking about any potential harms to kids in the state of Nevada. Now, I just want to point out to you who these people are that they chose. One of them is the Vice President of Product Management for Meta, and having served in this capacity since 2019, and also the head of Product Messenger. The head of Product Messenger. They brought the head of Product Messenger. So if the head of Product Messenger does not know if there is evidence of evidence about potential harms to children in the state of Nevada, the head of the company for this product doesn't know whether their product is causing harm or, as the statute says, causing important consequences to Nevada under the Trump case, one of the elements, then that to me would be evidence of willful ignorance. If the head of the company of this product line doesn't know if that's happening, but it gets worse for them because they also brought with them the Vice President of Global Head of Safety of Meta Platform Inc. Safety, the Vice President of Safety to come to this courtroom and be put under oath and testify as to whether or not their product is safe to kids in the state of Nevada. So we would like to, and by the way, I would mention this point, they came all this long way. They flew in from all over the place. They're here now. And we've taken the court's time. The court has set aside, and I happen to know a little bit about your docket, it's pretty full. You have a lot of other things you could be doing right now other than entertaining us today. So we now have the opportunity that you created for us, that we all stipulated to be here and take evidence. So what is the harm? What are they afraid of? Now, I just met Mr. Hester today, so I don't know him. But as an advocate, I'm reluctant to take his word to you that these people don't know anything about the subject matter, his witnesses. So what I would prefer to do as an advocate is put those witnesses on the witness stand, put them under oath, and test whether or not they have anything relevant to say on jurisdiction. Since we're all here, the court set aside an afternoon to do this, and it seems to me that would be a very good use of all of our time. We could take a lunch break, we could all go back, have lunch, and come back after lunch and put these witnesses on the witness stand. If they don't know anything about it, what is the harm? They're here, presumably they didn't have plane tickets to leave here until after 4 o'clock today. So we have the opportunity. They put us all in this position. We think that's a fair and reasonable accommodation under the circumstances, and if, just if, Mr. Hester is incorrect, and they actually have some evidence or some testimony and no more than he thinks or believes that they know about what Meta is doing here that they know is causing harm or potentially causing important consequences to children in Nevada, then it could actually obviate the need for a hearing on April 16th about that subject. And if not, we could talk about what could happen and what other discovery could be done between now and the 16th and go forward on that basis. So we think, Your Honor, under the circumstances that they created, which we believe to be actually procedurally improper, that would be a fair accommodation to all, and it would serve the purpose of using up the afternoon the court set aside for us and for that purpose anyway.
Okay, here's what the court's going to do. Counsel's articulated he has a right to object to the fact that realistically that an issue raised in an opposition should somehow preclude you moving forward of a preliminary injunction that was set by agreement of the parties after several hours of you all shuttling back and forth in various aspects of the courtroom in order to decide to have today. So what I'm going to do is I'm going to move forward after the lunch hour with the preliminary injunction hearing. Each side can put on the witnesses. I have to take that into account. Witnesses have brought in from all over the country. They're anticipating that testimony would be given. And realistically, I can determine at the end of the day whether I need to do a carve-out and do a carve-out with regards to my decision. I may need to defer my decision on the preliminary injunction to address personal jurisdiction, or maybe that gets resolved during the course of the preliminary injunction hearing. And I think that that's appropriate. The court was heading the other way because you all had an agreement with regards to the fact that the personal jurisdiction issue could be handled before the substantive preliminary injunction hearing. Now I'm hearing that there is actually an objection to doing so, and so counsel who's correctly stated that today has been set aside by agreement of the parties to move forward with the substantive preliminary injunction hearing. I've got a courtroom full of people who've taken their time to be here. And so I will move forward with it, and I can just determine at the end of the day, after hearing all the evidence, realistically, I'll have a transcript, I'll have discs, and so whether I make a ruling today or I have to defer my ruling because of other issues, then I can easily do that. But that way, witnesses who've already flown in from various locations, or people even locally that may be taking their time away from work, may or may not have to ever come back, at least for purposes of this particular hearing, because we can address that up front. So with that change in the viewpoint, we no longer be in agreement, then the counsel is correct. He has a right to have his preliminary injunction hearing move forward today, and the court's going to do so. We're going to break for lunch. I'll see you back at 1:15. Thank you so very much.
Thank you.